Yes, sir. Well, as moderator of the leadoff panel, I want to thank Chris Yu for organizing this Divestiture reunion for all us old guys that fought these battles starting in the late 60s. I am really honored to moderate this panel, for which the word illustrious, I think, is really too weak. All of you know, left to right, Roger Noll, Paul MacAvoy, and Fred Kahn, who were the giants of the day and remain giants even now. Each one of them had a profound effect on the policy outcomes at the time, and for me at least, a profound effect on me as a young economist being tested in the heat of the Bell System policy debates. It is both a pleasure and an honor to share a podium with these gentlemen. We also have with us a gentleman whom few of you know, but who was perhaps even more responsible for making this divestiture work. To my immediate left is Joe Weber. Joe was a bright young engineer at Bell Laboratories when he came across a gawky, feckless math guy and took me under his wing. I like to think that this was because Joe recognized my true genius, or maybe he just found me amusing, but he was my mentor and role model during an important time of my life. And he taught me to be very grounded. It's the thing I remember from Joe. Things either worked or they did not. You either understood how things worked or you did not.
That's for sure.
Joe had great respect for the former and little time for the latter, a lesson that has stood me in good stead throughout my life as an economist. I'll just let that rest there. Prior to divestiture, Joe was AT&T's technology point man for matters regulatory and legislative. So it was natural that he was on the committee of AT&T brass that reviewed the draft MFJ. It had 2 executive vice presidents and Joe. No prizes for guessing who really understood how the network worked. He insisted on significant changes in the technical appendix which actually governed how the network was to be put together and taken apart, which was possibly the key to the divestiture, and he carried the day. After divestiture was announced, Joe was put in charge of implementation. It was Joe who decided which company got which switches, which circuit groups, on shared circuits, what the leaseback arrangements were going to be. That was Joe's job, and he managed to do it. This was not only a difficult technical job, but a highly political one, both in terms of the DOJ, the Judge Greene court, remember Judge Greene? As well as the very poisonous relationships which had developed between the soon-to-be regional Bells and the soon-to-be AT&Ts. But in the end, this is the thing you need to remember, it was Joe Weber that teased that single unified system into 2 parts and made sure both of them worked. I'm glad he can join us today, and I think we can still learn from you. I'd like you all to hold your remarks to about 12 minutes, and I'll hold questions until each one of you has spoken. We can briefly address questions to each other, and then we'll open it to the floor. And I'm going to go to my left to right. So I'm going to ask Roger to lead off.
Thank you, Jerry. I've been to the 10th anniversary of the divestiture. I've been to the 15th anniversary, the 20th anniversary, and now the 25th anniversary. The only saving grace of all this is that every time I come, I see that all these other people are older, and the number in the audience is smaller, so there is a cap on how many times we can do this. So, and I do not intend to repeat the things that I have written about the effects of the AT&T case. Bruce Owen and I wrote a couple of articles in the 80s, and then Paul Josko and I wrote an article in the Stanford Law Review called The Bell Doctrine. That was for Bill Baxter's Festschrift. And I do not intend to rehash all that. Instead, I want to, if possible, say something new, because frankly, in an industry where technology has advanced as far as it has in communications, it is basically a fool's errand to try to get from the one ringy-dingy, two ringy-dingy world of 1983 to today. And so instead I want to talk about the intellectual content of US v. AT&T, not the details of who got what, but the very interesting, extraordinarily high level idea competition involving predominantly economists but also lawyers and engineers that had taken place for about 15 years prior to divestiture, for which divestiture represents one of the high watermarks of one part of this argument winning over another part. And I'm not even going to claim it won on the merits. I'll let Paul argue that. He always likes to argue the merits of the arguments. But instead it's just to sort of outline what was at stake intellectually in the case and what actually happened, and how subsequent events may or may not reflect on this intellectual competition. The essence of it all is that on the one hand, a vast literature had developed primarily in economics and engineering, to some degree in law, about what we might call the perfectibility of regulation. And indeed, that literature probably hit its high watermark roughly at the date of divestiture, with the creation of the basic theoretical foundations of incentive-compatible price regulation and entry regulation, price caps and all that. That was an extremely important line of research, and it represents the sort of AT&T side of the intellectual argument. The premise of that model is you accept the existence of regulation and the rationale for it in natural monopoly, and then you accept at least the in-principle perfectibility of regulation, in the sense it's really possible to monitor what the firm is doing, or at least create incentives for the firm to reveal to you what it knows and what it can do, and that you can create a world in which you have essentially a zero profit natural monopoly, zero excess profit natural monopoly, where there is no significant amount of distortion created by the regulatory institution. That is to say, there is technical efficiency in production. The regulated monopoly does not have X inefficiency, even with respect to the invention of new technology, let alone the factor choices at any given moment in time. And there's also no significant amount of distortion in allocative efficiency, because one has some sort of optimal pricing system, either through two-part tariffs or Ramsey pricing. So that's sort of one side of the model. A lot of components of this were invented in the 70s and early 80s. The crucial component that I think caused the AT&T side of the policy debate to have a firm intellectual foundation was the notion that a natural monopoly with perfect regulation could be unsustainable, right? This was the concept invented by Jerry Fallhaber when he was 30 years and 40 years younger, and Betsy Bailey and Bobby Willig and John Panzer and Will Baumel, that under plausible conditions of production function, technology, and demand, it was possible that under perfect regulation, a natural monopoly would still be susceptible to inefficient competitive entry, and hence one had to have rules that at least reviewed entry and probably prohibited it. Because then this gives rise to what AT&T's defense was in the case, which is A, the demonstration of natural monopoly, and B, the completely plausible argument that they shouldn't be required to do anything to facilitate entry anywhere in the industry. The other intellectual side of this argument had a completely pessimistic view of regulation. That is to say, the underlying premise was that regulation was inherently anti-competitive and imperfect, that it couldn't possibly set profits equal to zero even in expectation, because of the asymmetries created by the legal system of not being able to expropriate capital investments, so that that meant any errors in favor of the company probably would be kept by the company, at least in some measure, and any errors that were against the company that would cause its profits to fall below zero would be returned to it. So on average, over the long run, profits were going to be positive in any regulated market. And this is independent, incidentally, of whether it's cost of service regulation or price cap regulation or any other kind of regulation. And then the second part was that the entity itself that's being regulated was itself inherently inefficient because of the absence of the pressure of competition. And this was especially true in terms of choice of technology. That technological change was biased in certain ways and slower than it otherwise would be because of the presence of regulation. It wasn't, obviously you can't say that Bell Labs was an entity that didn't engage in innovation. What you can say is the presence of, in the argument by the other side, was that the presence of regulation distorts what it does and distorts the efficiency of the industry. Now, this led to, of course, two completely dramatically different views of the role of both antitrust and regulation in the industry. The first view leads to the conclusion that antitrust is completely inappropriate in this industry, that it is as if the regulators and the firm are always making reasonably good decisions, and it is an unsustainable natural monopoly. Just let them go and do their thing, and if people don't succeed in entering, that's their problem, because there isn't any efficiency-enhancing move you can make that's going to make things any better than will already happen with this efficient firm and perfect regulation, or reasonably good regulation. On the other hand, the sort of other side, the government side and the competitor side of the intellectual foundation of this argument, is that regulation is the problem and antitrust is the solution. That is to say, if there are markets out there where regulators and the firm have incorrectly concluded or asserted ought to be part of the monopoly, but in fact they can be competitive, then the solution to that is antitrust, not regulation. Because regulation is what caused the problem, and it doesn't have the tools and instruments to be able to fix those problems. So that's the essence of what was going on in the 70s, what the debate was about. It actually started in the 60s, reached full flower in the 70s, and the divestiture represented just, a victory in a battle for one side of that debate. I might add that I don't think that debate is over. It's not that I think this is a victory in a war. It was simply a victory in a battle. This is a particular industry, a particular case in which one side of this intellectual argument triumphed over another. There have been other debates of similar nature. Indeed, for the past 10 years or 15 years, we have been undertaking a series of battles in the electric utility industry that have a similar characteristic. And so that I think is the interesting part, and I would say one of the terrific benefits of US v. AT&T, which actually starts how I met Judge Posner. We were both staff members of the Rostow Communications Policy Task Force in the late 1960s in the Johnson administration, and it really started there. That this debate had been going on for 15 years about two views of regulation and antitrust, and it's been going on for 25 years since. And the contribution of, first of all, the task force, and then US v. AT&T, and some pro-competitive decisions at the FCC that were not very successful, is that it caused a lot of really good people to focus a lot of their energies to developing the intellectual foundations of each side of this argument. And what the first and the most important legacy of the case, it seems to me, is what it did to the intensity and quality of research, policy-oriented applied research in economics about regulation that happened in the 70s and 80s. Apropos one of Jerry's remarks, the number and average quality of 30-year-olds in the field of regulation is much lower today than it was 30 to 40 years ago. And there aren't very many Paul MacAvoys and Fred Kahns around now, compared to what was the case in the 70s. A very large fraction of the best graduate students in economics at that time chose this field to study, whether they were, whatever university or institution they were at, whether it was Harvard or Chicago or MIT or Stanford or whatever. And that's no longer true. People do not study regulation with the intensity they did then. Okay, so that's point number one. I think that's the first, probably the singularly most important accomplishment, is that it had a spillover effect on the advancement of thinking about the relationship between regulation and competition. The second important point, I think, has to do with trying to identify what was actually the purpose of US v. AT&T as opposed to the consequence. I'm going to get to the consequence in a minute, but what was the actual objective? And here I want to emphasize the way that Bill Baxter thought about it, because one of the features of US v. AT&T is that it went on and on and on and on and on. A lot of people went from being graduate students to full professors studying this case, and so the people who ran the case from the government side, changed every couple of years, and the case, as it was actually litigated by Bill, bore some relationship, but not a lot of relationship, to the case that was originally formulated in the Ford administration.
3 minutes.
Yep. Got it.
$5 will get you a fourth.
So the purpose, as Bill put it, was to identify and quarantine the durable part of the monopoly. Now, quarantine is the important word because the essence of the argument is regulation creates incentives for a firm to engage in expansion of its scope of activity that's inefficient. Why? Because A, if it can cause that expansion to bring something else under the tent of regulation, it gets excess profits because of the imperfection in the regulation system. Or alternatively, if it manages to expand its own scope and that new addition doesn't get regulated, it can use the monopoly part to advantage itself there and earn excess unregulated profits there. That was the essence of the argument. And then when you combine that with regulatory imperfection, and there isn't anything the regulator can do about it, that inefficiency then, by hypothesis or by empirical argument, can, even if it is a natural monopoly, it can be more important than whatever the gains and efficiency are from having a real monopoly where there are economies of scale and scope that would cause you, in a purely technical efficiency sense, to prefer a monopoly if you could regulate it perfectly. But if the imperfections of regulation may raise the cost of that so they exceed the benefits. That's the essence of it. The way to stop it then is to quarantine it. You limit the scope of the regulated entity to that which you have determined to be a monopoly. Now, Bill's belief at the time was that local access service was in fact a natural monopoly. He changed that view a few years later. My own view was that that wasn't true either, but that the problem of state regulation of public utilities was an intractable one from the federal government's point of view because of the jurisdictional separations in the various regulatory acts, whether it was Communications Act or Power Act or whatever. So the idea was the same. There is this thing out there which you can't get your hand on, which is state control of local access, whether it's electricity or anything, or telecommunications or anything else. Let's quarantine that. And the objective in the short run is to stop, to put a structural barrier against the firm responding to the incentives that are created by regulation to expand its scope in inefficient ways. And in the long run, if you're lucky, you will actually induce competition in the things that could be competitive, and regulation can go away. At that point, you rely on antitrust, not regulation, to keep the industry competitive. And that has an implicit theory of antitrust as well, which is that antitrust can be relied upon to work if the industry already has competitors in it that are going to become dead bodies if an anti-competitive strategy works, whereas antitrust is less effective if the Anti-Competitive Act occurs before there's competition and keeps and creates a barrier to entry, but there aren't any real dead bodies. And the reason, of course, is the organization of interest bias issue with regard to antitrust, that the guys who are going to profit from the possibility of entry and the possibility of being in this market don't exist yet, so they're not going to either fight the antitrust cases themselves or lobby Congress or the FCC or the Justice Department or whatever to fight the battle for them.
Roger, I think I have to be an effective regulator.
I have one more sentence and I'm done. So
No semicolons.
the one last sentence is,
No ands.
given this is the case, what does it matter? And I just want to raise this as an issue. What we learned in the actual divestiture was that judges are no better at regulation than regulators, that the structural relief idea was partially replaced with a regulatory relief idea, which distorted what happened in important ways. But we still have to ask the question, and this is the very last point. AT&T's crucial behavior was denial of equal access. What would the world look like today if equal access had been declared by the courts not to be required? Had AT&T been free of any potential either regulatory or antitrust liability to prevent interconnection, not just with long distance, which doesn't really matter anymore, but internet services and wireless? Would we have a competitive internet services industry and a competitive wireless telephony industry, which we now have, if that one event hadn't occurred? I think that is the right question about what the long-term effect of the case was. I don't have an answer, except I think at best these things would have been delayed had AT&T won.
I think we need a new incumbent. Okay, and we'll move to Paul MacAvoy.
Jerry, how much is it going to cost me for an extra minute?
Well, given the inefficiency of regulation, we just might run over.
I would like to start with after divestiture and continue as close as I can to today, but to some extent I want to add to just a sentence from a source. This is from the noted contemporary historian Stephen Call in his book on the antitrust case. Call says a number of very sharp things that could wake us all up far beyond what the provost did. But if you really want to be wakened by Call, you should read his new book on the bin Laden family. That will keep you awake for a month. He says the crucial decisions made in the industry and in antitrust during the divestiture proceedings were driven by opportunism, short-term politics, ego, desperation, miscalculation, happenstance, greed, conflicting ideologies and personalities. And Charlie Brown thought that there was nothing left, when he thought that there was nothing left, a perceived necessity, there was no other thing to do. Well, that's before divestiture. My paper is entitled A Learner Index Analysis of AT&T's Performance in the Wireline Long-Distance Markets After Divestiture. The day of creation of divestiture, I personally was the next witness for the defense, scheduled to be called before the antitrust court. Therefore, I was never heard. But I did have a seat at the table to listen what was forthcoming from AT&T, the sponsor of divestiture, and the antitrust division, the receiver of the proposed settlement. It was evident to me that AT&T management expected to become the long-distance dominant wireline service provider in nationwide business and residential markets, free of price controls at the Federal Communications Commission. That was the core. The antitrust division never said that divestiture from the local exchange companies was expected to result in anything, never mind effective long-distance competition. Instead, the divestiture process, plus open entry, seemed to be meant to create as many new carriers operating as possible over numerous duplicative and redundant carrier networks. Only the head of the division, W.F. Baxter, his friend, made a connection between the new networks and deregulation of long-distance service suppliers. Only he, and he was totally separated from the case process. The antitrust court, Judge Greene's district court, had plans of its own to manage the process of creative duplicative national networks. The local exchange companies were forced to build out their interconnection nodes to provide parity for all old and new long-distance carriers in picking up and delivering calls. In the transition period before parity was achieved, from 1984 to 1990, the regulated charges for interconnection favored the other carriers so that these new carriers expanded market share relative to AT&T. AT&T lost a third of its 90% plus share of call revenues in both residence and business service national markets, accounting for revenue share of AT&T and those of the two nationwide entrants, MCI and Sprint, with comparable national service offerings. The Herfindahl index fell from close to 0.9, 9/10, indicative of a market structure in which there were an equivalent of 1 1/10 independent firms, to 0.5, similar to those for two equally sized firms by the end of the first dozen years of the court remedy process. But the prices in AT&T's tariffs were still subject to caps set by the Federal Communications Commission, because AT&T was defined as a dominant firm by the FCC, while MCI and Sprint were not. The caps were seldom limiting. The FCC process did make it possible for the three carriers to set the same prices at the same time by having AT&T submit its tariff to the FCC first, and the other two examined that tariff and followed along with something very close to AT&T's prices. Even so, to lose a third of total revenue share by the early 1990s, a decline had to come of some sort in AT&T's price levels. In fact, both residential and business charges declined, but so did the regulated inter-exchange switching charges that constituted the largest share of long-distance costs, 60% of long-distance costs. All wireline long-distance prices for services went down, but not by as much as marginal costs for these services. Price net of marginal costs as a percentage of price, the famous Lerner index, steadily increased on standard plan services. Even on discount plans, contracts of services to which large numbers of residential subscribers were switching, margins increased from 58 to 68%. 68% of any dollar paid into AT&T for discount services was profit margin. The AT&T share of wireline revenues ceased declining in the early 1990s, while shares of the other two firmly established carriers with national networks ceased increasing. Demand functions were still inelastic for the two main residential services, standard and even discount. But price-cost margins, the Lerner margins, were not indicative of competitive pricing. They were too high and were increasing after market shares had stabilized. Prices increased, price-cost margins increased year after year after year after market shares stabilized. If not competitive, then what is this? The market structure was characterized by one large carrier and two others, each able to provide full service. That's essentially the structure of an oligopoly. There were limited price differences, mostly associated with discount packages for MCI versus AT&T, but Sprint copied the prices line by line from AT&T's tariff. Then the what question is, what kind of oligopoly? With tariffs at the FCC putting in place one-shot price schedules over preset market shares, that held for most of the year. The kind or classification of oligopoly, of course, was Cornell, which implied that an HHI equivalent to two firms, HHI of 0.5, would result in a Lerner index half of that you would have if there were a long-distance monopoly. Given that these pricing margins were, in fact, a result of an AT&T strategy, which I believe, the AT&T Lerner index would be the product of market share multiplied by a so-called strategic factor divided by the market demand elasticity. That factor, the coefficient of conjectural variation, determined that repetitive responses of the two smaller network service providers would either complement a conjectural variation coefficient of +1 or substitute a coefficient of -1 for service initiatives of AT&T. Complementary responses to changes in AT&T service offerings produced, when V is +1, collusive or joint profit maximizing margins. The change in Lerner margins from the mid-1980s to 1997 were neither positive or negative. The second and third carriers did not follow in lockstep to undercut AT&T, nor did they follow in lockstep to provide expansive support that was necessary to allow AT&T to set tariffs at the joint monopoly level. From year to year, the AT&T conjectural variation ranged from 0 to -0.3, values associated with Cornell, with some disregard, that is, of the responses of the two smaller providers. But the large service provider, AT&T, was not able over this long period to totally ignore the others. The Lerner margin was too low to be a monopoly margin by 20%, and the elasticity of demand was still large negative to validate too negative to validate a strategy of monopoly pricing. In 1996, with the passage of the Telecom Act, this all changed. The posting of tariffs for the benefit of the collective price decisions of the three carriers disappeared, rendering it difficult. This is going to be a $10 additional charge. Disappeared, rendering it difficult. I haven't come to the new stuff, Jerry. Rendering it difficult for the largest carrier to take the lead. The merchandising practices of the companies to stabilize shares turned to simplification of pricing with such announcements of cents per minute for very complex packages. The mechanics for knowing what all three major providers were doing, sufficient to allow them to continue to practice Cornell, was still there, but were very substantially weakening. In addition, new determinants of price formation were against stable Cornell price margins. I take a paragraph to talk about cell phone service, what that did to the elasticity of demand. I take a paragraph to also talk about the behavior of MCI, which was sufficiently irrational to have an effect on the market. But significant non-market pressure was exerted by the FCC in the other direction to increase Lerner margins. The FCC wanted to increase Lerner index margins. This is because new funds were necessary under the 96 Act to provide universal service, which had to be collected from long-distance subscribers, and that called for pass-through of universal funds taxes. But with Cornell pricing, these carriers had to absorb some percentage of the tax, so that only a more collusive pricing arrangement could result in the larger cash flow necessary to fully recover the Universal Service Fund surcharge. In the post-Telecom Act period, with USF charges, Lerner margins for AT&T increased from 60% to the low 90% range for standard residential service. 90% of every dollar paid in by customers was a profit margin. Its learner margins on discount plan services increased from 60% to 70%. These estimates were in excess of those consistent with a continuation of Cornell. They were consistent with price levels higher than Cornell and pass-through of the U.S. charges. That all three carriers succeeded in more than full recovery was indicated by an April 2003 FCC order limiting recovery surcharges of USF funding only to the required contribution. They were making more in surcharge recovery than the contribution. Okay, here comes the first dollar. Did AT&T conspire with the FCC to set long-distance joint monopoly prices? Its learner index values clearly resulted from some new collective strategy. In most years, the estimate of conjectural variations increased to greater than 1.0, indicative of a strategy to jointly set the monopoly price level. That is, given a learner index of 0.88, the conjectural variation coefficient equaled 1.2 for standard plan wireline and 0.9 for discount plans in place. In standard plan services, AT&T had prices up to monopoly levels, while in discount plans where price-sensitive customers migrated to wireless in large numbers, prices were not at monopoly levels, not quite. Two more paragraphs, Jerry.
You're keeping us all from hearing Fred Kahn. You understand that?
I'll pay Fred.
I cede my time to the gentleman.
Thank you. Just two paragraphs, Fred. Thank you. You've been kind to me all your life. In a speech to the people of AT&T on November 18, 2005, the CEO of AT&T of the hour, there have been so many of CEOs of AT&T I can't count them, put the current conditions succinctly. Quote, "The old business we had worked fine with the higher price levels," noting that with the shift to discount plans, we have serious trouble given the direction prices are headed. He put it in another way, our customers needed what we have to provide for them, but competitive price levels have made it impossible for us to make a profit with the current competitive structure. This is preceding the movement with the FCC into USF pricing. Now that AT&T long distance is once again part of a local exchange wireless carrier, and after I have written countless papers and books on oligopoly and regulation in this industry, this is my last inquiry into the failure of antitrust and regulation in telecommunications. I cannot work without being able to define markets, without being able to define prices, without being able to use the learner index to unravel industry performance. And they are now gone in a mainstream of packaged, bundled services over 4 industries. One can no longer tell what the oligopoly is doing, so I quit right here and now.
Excellent.
I knew you'd be happy.
Paul, your bill is now up to $423.50. I'll accept the Visa or MasterCard.
I'm giving it to Fred.
Thank you. Fred Kahn.
It was with goodwill that I ceded some portion of my time to Paul, because in fact, despite my association with telecommunications for a period going back to something like 1960, I have never been engaged in the kind of active involvement in either the antitrust proceedings, the MCI, very famous MCI case, the negotiation of the consent decree. In all those respects, I was otherwise engaged. So that's a certain disqualification. On the other hand, I take the advantage of privilege of age to engage in some ruminations that bear on the question of whether the decree was successful or unsuccessful. First of all, I heard Bill Baxter once after the negotiation of the MFJ talk to a meeting of economists professing, with, of course, false modesty, that he felt like the sheep that was, or the lamb that was tethered to a stake at the edge of a town overnight in order to test the validity of the rumor that there was a wolf in the vicinity. That was, of course, false modesty on Bill's case. I was not involved, and therefore, to this day, I don't have a clear notion of whether the dissolution was or was not important, or it was important, but was it effective? My involvement became much more intense after the dissolution, after the decree, and with the enactment of the 1996 Act. And the combination of those, I submit, did finally achieve something of what Bill Baxter had in mind, and that is the introduction, ultimately with all the mergers, not all of which I would have approved, the fact that we do have effectively a duopoly of multi-platform suppliers surrounding Verizon on the one side and AT&T on the other, with Sprint and Nextel really faltering, and it's not at all clear to me that we have much more than a duopoly. So the contribution of the dissolution, setting aside Paul's, and I don't mean by setting aside, ignoring Paul's analysis of whether in fact it produced any beneficial results, was that it did indeed finally lead to a genuine duopoly centered on, one, the remaining BOC, and the other AT&T with its acquisitions then of Southwest Bell and Bell South. That is still troublesome to me in my interest in the provision of Internet access. I will be much more comfortable if, in fact, we had at least three. That is to say, if wireless did really emerge as an independent, vigorous, independent force.
What if there are only two airlines?
Say it again?
What if there are only two airlines?
I'll come
Aren't you
back
going
to
to be
the-
more comfortable?
No, but there's nothing in the airline industry that is capable of being comfortable. That we immediately shed responsibility by saying that the FAA, air traffic control systems, have never done what I publicly insisted they do back in 1978, which was to respond to the great increase of traffic that I expected we would unleash by pricing their crucial infrastructure services of airports and air traffic control, following the same principles as we were trying to apply with respect to electricity, telephone, and natural gas back in the early 80s. And of course, that's been a crashing failure to this very day. This is forgive this illusion, but it's very hard for me to come to somewhere where someone doesn't think, yeah, but look at the mess in airlines. To take the simplest example, air traffic control is financed in two ways: a tax on fuel and a tax on passengers. That means that there's absolutely no element of congestion pricing. It means that it gives an enormous preference to light planes. There may have been some logic in pricing on weight, and therefore also fuel consumption, when it may have been associated with wear and tear on the airlines, on the runways. But the most severe problem of congestion has been there's been a total failure to meet the absolute need for more intelligent pricing. And just, if you muse for just a moment, what a tax on fuel consumption and on passengers does to the competitive balance between large planes filled with a large number of people, taking up something like the same space as a single plane, very light on use of fuel, no passengers, which indeed creates more need for spacing than the large planes because of the turbulence problem. Enough of self-vindication in that area. The other side of it, of course, is if you look at Mickey Maynard's article in, was it yesterday's Times, the other side of the thing is that, remember, the safety record has improved dramatically, as we indeed said it would when it was widely predicted that planes would be falling out of the skies if we deregulated. Because, of course, we never deregulated safety. But we're never going to solve this problem unless we take air traffic control and the setting of fees and the financing out of the hands of Congress. And that's been the principal problem there. That takes more time on that than I intended. I thought the case of Bill Baxter was ironic because, after all, he was a Chicagoan. And in general was an ardent defender of vertical integration. But the Chicagoans always recognized at least one, although I felt there were others, but at least one respect in which vertical integration, incorporating one horizontal stratum that was regulated, would always produce a defective performance. And therefore, in that respect, the MFJ made sense. But in point of fact, it wasn't that created the basis for competition. Inadequate, as Paul points out, though it may have been, but ultimately the 1996 Act, which has been much maligned. And I devoted several years of my efforts to getting the LECs freed of the restriction from entering into competition with AT&T. And that proved to be very important. I saw it was in effect they were enforcing the 14-point compliances at the local level, and I won't spend a lot of time on whether that's been successful or unsuccessful, and the FCC's attempts artificially to introduce what was in effect merely parasitical competition, sort of a reseller, making it even more attractive for resellers than for people putting in their own switches. But what I did perceive was that we really did begin to get effective competition in the long distance market once the LECs qualified in satisfying the 14 points and began to enter into direct competition with AT&T. There were cases there of really very deep cutting price competition, which, as I say, in a sense, ironically vindicated Bill Baxter 20 years after the fact. To come back to the question of whether vertical integration or disintegration in divestiture was important, I must confess that I was less sanguine than Bill Baxter about it. I had had many, many years of association with the Bell system. In some respects collaboratively. I was a member before Paul of the 3-person National Economic Advisory Board to AT&T.
You replaced me.
Oh, I replaced you? I thought
I went into government.
Which one of us is older? Never mind. I was there from 1968 to 74, and I thought I was one of the first. But Bill Baxter and Otto Eckstein and I. And what I Well, in fact, my relationship goes way back to when I was in the Arthur Burns senior staff of Arthur Burns Council of Economic Advisor. That was in the 1976-77 period. No, sorry, 1956-57. How these decades fly. When the FCC issued its abominable Hushaphone decision. And I came to Arthur indignantly, and I remember my most famous line was, AT&T said it would interrupt the quality of the service, and therefore the FCC at that time sustained the prohibition of the attachment of this plastic device because it interfered with the quality of sound. And I remember saying in my memo to Arthur, all the person at the other end of the line had to say was, take that goddamn attachment off your phone, I can't hear you. In any case, that was one of the beginning AT&T resistances to competition, beginning even earlier with its resistance but the FCC deserves enormous credit for the above 890 decision, which did begin to introduce the possibility of effective competition in the long distance market. That eventually was satisfied. Okay, 1 minute is really all I need. I myself was not a Chicagoan, but I went back and looked at the section of my book on vertical integration in telecommunications, published way back in 1971, and I was very timid about divestiture. I thought that there were real, I've forgotten what the word is, efficiencies consequent upon the association. Well, in effect, I was wrong. Ultimately, the 1996 Act did open us up to the kind of competition that we were supposed to have. My remaining and continued concern is about the mergers that have been permitted in the industry. Today, the issue is the adequacy of competition in access to the Internet. And of course, that issue is behind the really hot political issue today, which is in many ways an abomination and terrifies me, but the pressure for legislatively enacted network neutrality. I would feel much more comfortable if we had a genuinely independent third competitor, and that would be potentially wireless. I mean, someday we'll get it over electric power lines, but that day keeps moving just about as into the future, just about as fast as the calendar. In those circumstances, to have permitted Verizon to acquire, what was the German? I keep forgetting the name of the German. I'll think of it in a minute. To have permitted it to acquire the number 5 firm, to have permitted AT&T after it had acquired Bell South to acquire what's the name under which they sell
Singular.
What's it?
Singular.
Singular, thank you very much. So that in fact the Singular name is indicative. From 5, we are now down to 2 effectively long-distance access suppliers, which continues to open us up to the network neutrality issue. Notice how I've slipped away from the issue before you today to the issue that's before us tomorrow and in the future. And the failures have not been the divestiture of AT&T. The failures, I believe, have been in the merger policies, which have failed to recognize how important it is to have 3 genuinely independent providers of Internet access. I yield my remaining negative time.
Yes, even Fred must obey the regulator. Okay. Our last speaker is Joe Weber.
Yeah, Jerry, Chris, I have that little gadget you were going to discuss.
When I was at Bell Labs, I don't know, 140 years ago, Joe actually taught me how to use what we called then overheads, which is now transmogrified into PowerPoint. So he's going to be using it.
Yeah, well, thanks, Jerry. I have to thank Jerry very much for that really effusive introduction. And everything he said was true, almost. But well, I'll accept it as it is, although I must confess I didn't do the divestiture by myself. I had some help. I'm going to use a few slides here. And my general theme here is going to be, as you'll see, that I think that the regulatory events in this industry over a long period of time were driven much more by technological advantage and commercial opportunity than by economic theory. And so that would be my general theme here. Hopefully there's a slide here somewhere.
They're on the computer, not on the screen. Yeah, he's still working on it. Why don't you? Let's see if we can talk through the.
Well, okay, I'll start talking.
Well, laboratory engineers cannot run computers.
I'm not running it. I'm just the operator here.
He's the long guy.
It's not my responsibility.
He's just got the
if I were over there, I could make it. Anyway, I think I'd like to start and say, I start with saying, where was telecom in the United States in 1960, before all this stuff started? And basically, AT&T had operated an integrated telecommunications network for over 50 years, and it had been regulated and controlled. Theodore Vail had set the policy back in 1913 as a single system, and the objective was to get universal service. And indeed, that was the entire motivation for the entire organization for that period of time. Service was the paradigm, service was the objective, and they proceeded to accomplish that objective. By 1960, we essentially had universal telephone service in the United States. About that time, coincidentally, some large, some small, began to appear, and these technologies provided various competitive opportunities. And I've named 4 of them specifically, 2 large and 2 small. The large ones were the microwave radio systems, which had actually been developed, of course, by Bell Labs initially, but now were publicly available and could be used by others if they wanted to provide service to themselves. The second and most important thing was the advance in the semiconductor industry, which allowed the construction of switching systems, which were made out of semiconductor devices rather than relays and whatnot, which made them a lot more flexible, a lot less expensive, and useful for a wide variety of purposes. The other 2, which were smaller but ultimately had a major effect, which was the development of the introduction of this little miniature connector for telephones and other terminal equipment. And although this is not a major, important technological advance, what it did do was made it possible to interconnect terminal equipment very easily to the telephone network. And the third one was tone signaling, which allowed signals to be sent over the telephone network from the telephone after the connection was established. And this turned out to be very important as long-distance competition developed. Do we have anything here yet?
Nope. Well, we got a lawyer and 2 economists working on the technical.
We looked at it before on the screen of the computer.
Trying to save him from indictment.
That's right.
Okay. So what happened between 1960 and 1980? I think that was the period during which all of the regulatory and competitive pressures began to grow. I think although there were various economic theories floating around at the time, basically, I think one of the driving forces was that AT&T was very large and growing very fast. I think it was some large fraction of the GDP and growing faster than the GDP. And I think there was a general concern that a private entity of that size could not really be very well controlled. And they were having trouble controlling it. And so what the FCC did, with the help of the courts in some cases, they exploited these technologies wherever they could to slow the growth of the Bell system. They did it rather cautiously. And they started off with, first they allowed private people to use these private networks to provide their own internal services, the so-called over 880 decision, which allowed them to build private networks for their own internal telecommunications. And they allowed, augmented connections to the network, like the Carterphone, which Fred mentioned. Okay, good. We're over. What slide are we on here? Okay. Okay, so what is it? I can't see it, unfortunately. No, we're back. We go back.
This is the first one, it looks like.
This is the first one? Yes.
You the canal.
All right.
Okay.
Which way do I go?
Whoops, turn it on.
I just turned it on.
That takes care of that.
Now we got another economist about to jump in here.
Okay, I saw I pushed the wrong one. I turned it off. Turn it back on again. I just turned it off.
There you go.
Show them how to advance it. How do you advance it?
This one? Advance it to this one.
Hey.
Okay.
Okay, there you go.
All right, there we go. Yeah, okay, there we go. Okay, so I just have been talking through this thing. So they allowed connections to the network. Carterphone was a simple extension of the network. It was an acoustically coupled gadget. You put a telephone in a cradle, and it was a radio system that allowed you to extend the call to places which the telephone service didn't go. So that was pretty modest. And then MCI began to offer long-distance service, initially private line service. The FCC allowed it to interconnect, and then after a while they began to offer switch services, the so-called ExecuNet service, utilizing this tone signaling method to be able to signal to their network over the local calls. That turned out to be pretty pivotal, because what they were doing was they were using the local network at local business rates and avoiding the subsidy which it had built into long-distance charges for a long period of time. Finally, the FCC, going one step further, actually deregulated terminal equipment and allowed open interconnection to the network. And all this time, the FCC was struggling with the issue of what they called information services, because computers services and communication services were converging. AT&T was constrained from being in the computer business, and the FCC kept struggling, trying to find definitions and strictures of ways in which AT&T could offer information services, not very successfully, I must say. AT&T, of course, resisted all of these initiatives. They resisted Carterphone, they resisted interconnection, they resisted long distance, they resisted all this stuff. But in the end, it all went through anyway. In fact, what they did, one of the things they did in terms of terminal equipment interconnection, they developed something called a concept called harms to the network. The idea was that terminal equipment would hurt other people's connections, but they never could find any evidence of it, and ultimately the FCC just swept it away. So all these things went forward. The most significant thing that was happening during this period was we got long-distance competition with MCI and Sprint, and we had terminal equipment deregulation and interconnection. But despite all these initiatives, in 1973, the DOJ, in the midst of the Watergate scandal, filed an antitrust suit against AT&T. So then we had, hopefully, there we go, okay. So we have the settlement, 1981. And in mid-1981, Judge Greene, this thing had been dragging along, as these things always do, and Judge Greene signaled that AT&T would probably lose the case. He said something to the effect that he had seen ample evidence that AT&T had violated the antitrust laws in a variety of ways over a long period of time. So AT&T got the message that they weren't going to prevail in court, so they really needed to settle. And they began to look at various possibilities. And they had some injunctive proposals. I actually was involved in making recommendations about those, and generally felt that they were so constraining in terms of what the company could do that we really couldn't operate. We just couldn't operate the business under the kinds of injunctive constraints that were being proposed. And several divestiture options were explored to divest parts of Western And that didn't seem to go very far. And then finally, the divestiture as it came about was proposed to divest the telephone companies, the local exchange business from the long distance business, which was really kind of a revolutionary idea to those of us who had always thought of the Bell System network as sort of a sacred, unified object, which had been carefully built and nurtured over a long period of time. But it has certain advantages. AT&T kept Bell Labs, which they felt mistakenly was the jewel in their crown. The real jewel in their crown, of course, was the local monopoly, but they didn't realize that at the time. And also allowed them to go into the computer business, which they thought was the other grand opportunity. You know, the grass is always greener kind of thing. And of course, they couldn't do that either. And it was clean. It resolved both the long distance and the manufacturing questions, because one of the allegations in the antitrust thing was that AT&T had discriminated in its manufacturing of equipment. But it was extremely complex and costly, and nobody really knew for sure exactly what would happen to telephone service when they did that. I mean, it was just a complicated business of tearing this thing apart. So I've just listed in the next slide just some of the detailed implementation issues here that we had, just to illustrate the kind of complexity we had. First of all, where was the point of interconnection? Where did the long distance network end, and where did the local network begin? And the DOJ and the other companies wanted them to be a switch. There was a collection switch, which we used to call a class 4 switch, which was a collection switch where local traffic would get funneled into this collection switch and then routed out over the telephone network, the long distance network. But we pointed out, or I understood, that every switch in AT&T's network was a collection switch, every toll switch. And so if they took those switches and put them on the telephone company side, AT&T would basically be a bunch of wires, which would have made it hard for them to operate. And that was one of the most contentious items in the negotiations of the MFJ itself. It was finally concluded that the point of connection was at the local switch, and some of the telephone companies subsequently built collection switches that they used to collect the traffic of these other people. But then there was all sorts of other questions. How would the local service areas that the telephone companies were allowed to participate in? 2 minutes, okay. How big would they be? And, you know, there's a drawback to that because, you know, the smaller they are, the better off AT&T is. The larger they are, the better off the local telephone companies are. There's a lot of tension there. How would equipment be allocated between the local telephone companies and the long-distance companies? Generally used a usage model on that. The local switches had to be reprogrammed to accept multiple carriers to provide equal access. That, by the way, is one of the things that would not have been possible prior to the development of electronic switching systems. And indeed, at the time of divestiture, some 20% of customers were served by electromechanical systems and could not, at that time, get equal access. We had to provide billing and private line provisioning, and equal access, of course, overhung the entire operation very much. So in the short-term effects, in 3 to 5 years, were the monopoly and competitive distinction was soon abandoned right away. That was the clean idea, but that went away quickly. Yellow Pages and cellular, which were competitive, went over to the telephone companies because it was thought they would be otherwise not viable. Service levels were maintained except for private line provisioning, which was a disaster for about a year. And long-distance competition increased, but AT&T maintained dominance for some time to come. Although they had a declining market share, they remained the dominant carrier for some time. And the local telcos it instantly began to press for entry into the long-distance business. So over a longer period of time, of course, we had the Telecom Act, in which the VOCs traded their monopoly for their wonderfully lucrative monopoly for the ability to get into the, at that time, dying long-distance business, and local became competitive. AT&T was no longer dominant, and it was unable to penetrate the computer market. A telecom bubble grew as a result of this, and then collapsed, and a lot of overcapacity was put into the ground, which caused tremendous pressure on prices. FCC, as Fred pointed out, attempted to artificially introduce competition by forcing the local companies to lease portions of their network to their competitors at regulated rates, and that ultimately came to nothing. So where are we now? Well, telecom is just one provider. The telcos are just one provider of telecom. Long-distance carriers have been absorbed by the local telephone companies. The industry is dominated by the various other carriers, wireless, internet, cable, and all the markets are competitive. And the equipment business has basically been overtaken by IP technology, so that the once dominant, wonderful companies like Western Electric have essentially gone. Western Electric became Lucent, which got taken over by Alcatel, and is now the whole caboodle is probably on the verge of bankruptcy as we currently speak, because they've lost their market share, again, because of technological change. So all of these things happen mainly because of technological change and the commercial opportunities, and the regulators essentially followed the commercial opportunities fostered by the technological change. So I come up with a couple of lessons here, which is that industry forms are probably influenced more by technology than by legal and technology and the associated commercial opportunities than by regulation or legal action or economic theory or any of those things. And that industry changes spawned by litigation, such as structural change, are often expensive and they're certainly disruptive, and they may have unexpected results. We have lots of competition in the telecom industry today, but it's nothing like what I ever expected it to be when the Bell System divestiture was agreed to in 1982.
Thank you, Joe. I think we ought to move directly into questions from the audience. Greg Sidek, did you say who you were? There you go. Good.
Push the button on the right side at the front. The green light will come. Yeah, now we can hear you.
My question is stimulated by Fred Kahn's remarks and by Paul MacAvoy.
I'm having trouble hearing you, Greg. I'm sorry.
My question is stimulated by your remarks and by Paul. The divestiture is a vertical case, but Fred, you say that looking forward as we hear questions of net neutrality, platform competition between wireless and wireline is an important issue. So my question is this: will there be a drumbeat for a different kind of divestiture in the future, namely horizontal divestiture of landline from wireless networks for internet access?
Will there be a demand for horizontal divestiture between wireline and wireless?
Wouldn't there be a
Will there be pressures to divest the wireless carriers from the wireline carriers?
Well, I suspect there will be if indeed Sprint Nextel fails to. It seems to be uncertain whether they're going to survive, and their ambitious plan to extend WiMAX nationally, which would have been a sort of sign of real viability. If they get back to being a duopoly, I think we're going to have the same problem we had before. It's going to be, I think, very hard to resist these pressures for network neutrality, which is an effectively re-regulation, prohibition of price differentiations that make very good sense, that are not discriminatory, and that kind of regulation is going to get more and more intense. So I may be exaggerating the effect of AT&T Bell South's acquisition of Singular and Verizon's acquisition of that other firm whose name escapes me, but the numbers, the six, Remember when we were involved in litigation with the FCC to increase the number of what we called then personal telecommunication service, to increase the amount of spectrum so there would be as many as 6 independent wireless competitors. If in fact, however, number 5 was acquired by one, number 4 by the other, and the number 5, Sprint and Nextel joining, turns down to 2, I suspect we may be in trouble again.
Roger, do you want to have anything to
My name was mentioned. They didn't mention his name.
Nobody did, but you heard it that way.
17 minutes.
He already owes me $423. Go ahead.
He got the money, I got the time.
Okay.
If we have X number of independent wireless entities and Y number of bundled wireless, wireline, cable, text entities today, by extrapolating history, which is about all we can do within the context of this regulatory antitrust complex of Washington activities, we're going to have less X and more Y, or less X and the same number of Y 5 to 10 years from now. And I strongly endorse Fred Kahn's call for research, and that would be to see what the duopoly or triopoly or oligopoly with 3 are actually doing. What are the efficiency implications of Bertrand versus Cornell versus collusive activities among these 3 firms? I wish John Thorne were here, because if you just mentioned the name AT&T 5 years ago, it caused him to spit in 5 different directions about inhuman automatons over there that were destroying civilization as we knew it. I would envision John Thorne sitting up back here saying, well, you know, AT&T's not so bad. We can work with them. And working with them when there are 2 means they ought to do better than Cornell. And I've seen far less Bertrand behavior in these markets than I have seen. I spend 2/3 of my time on natural gas transmission markets, and I see all kinds of horrendous Bertrand behavior. That means prices close to marginal cost, Lerner indices close to 0, which is fine for now, but does not generate investment activity that keeps the pipelines running 5 to 10 years from now, never mind expanding into the new gas production areas in the Rocky Mountain east. These 2 or 3 companies are going to get along, and they're going to produce profit margins if you can ever get them to give you the numbers, which, you know, I quit this game because I don't think they'll ever give us the numbers. But if you ever had the numbers, then just like trying to separate out long distance from local exchange before the divestiture in the numbers that the monopoly AT&T had embedded in its accounting, you would find that profit margins, when the number of wireless firms decline or become enmeshed into mergers, is going to go up. And they were going to have more Stackelberg and joint profit maximizing behavior. And that's about as good as we can get. It's not as good as monopoly. Monopoly is more efficient than Stackelberg or Bertrand or Cornell. Bertrand is the worst because it does not generate investment. Bertrand describes Kahn's industry very, very well as far as I'm concerned. As soon as there's excess capacity among these 5 airlines, then prices go to marginal cost, and they don't buy any more airplanes. And then, oh my God, there's 20% more human beings want to get on our airplanes. And there are no airplanes. And no crackers, no cookies, but long waiting lines, not just to get on the airplane, but to get 3 seats in a row in the terminal so you can sleep all night in the terminal. That's pure Bertrand, pure Bertrand. Price equals marginal cost and is 1/2 of average total cost.
Paul.
And we have that in gas, and we have that in airline. It's endemic in these network industries. We sure don't have it in telecom. I think they're too good at collusion.
Paul, I think you're up to $782 now. Maybe, and Roger.
The money with me. I knew it would happen.
And Roger wants to talk.
Yeah, I want to respond to both Greg and Fred in the following sense that the nature of the technology in digital communications, whether by wire or by wireless, is such that we're moving to a world in which it's almost all fixed costs and very little marginal cost. And in that world, Fred, you don't need to worry about the disappearance of the Sprint Nextel or the T-Mobile network, because if they go bankrupt, as long as they can collect $1.50 in revenues, they're still viable, and as long as they're still viable, they're still a competitive threat. And just apropos of that, another example of how very large traditional companies make stupid mistakes. About 1.5 years ago, General Motors decided that it would not resell OnStar, which is its telecommunications emergency service, to its automobile competitors. So all the automobile companies in the world today are in the process of inventing their own alternative because they have to have it up and running by the end of this year. And I have been talking to a couple of these companies. This is an interesting fact of life. Thus far, the tests indicate that the Sprint network works better than the Verizon network as a mechanism to build communications into automobiles. Why? Well, its coverage is less, but it turns out the places it doesn't have coverage of the places almost nobody is, and the quality of the network they have in the places where people do live is higher. So I expected Verizon actually to win that contest, but apparently they're going to lose it to Sprint.
Another question. Tim Wu. he was arguing that the divestiture, okay, didn't really break up the horizontal monopolies of the regional bell companies. So what was such a big deal about the divestiture? Is that about it? Okay, he's saying even with the breakup.
Just to help introduce this, the divestiture was initiated by Charlie Brown for the purpose of getting rid of the rate-regulated local exchange networks as far as income-generating properties of AT&T. That's the only reason divestiture put the local exchange companies aside, because AT&T didn't want them anymore.
Roger, why don't you take a crack?
Yeah, let me take a shot at it, because I think you're absolutely right if you believe that wire internet connection, high-speed internet access, is the dominant technology. If you believe that fourth-generation wireless is competitive with wireline, then what really matters is whether there's independent competitive wireline. And even in the world of three wireline access companies, in each of those territories there is a major, one of the two major wireless companies that is not connected to the wireline, either the cable company or the local access telephone company. And then in addition, there's the minor players, which are T-Mobile and Sprint. And then the last point, which I think is terribly important, which is why I want Evan Guerrero to be made the czar of spectrum. If you replace the current strategy of using wireless auctions to maximize revenue to the government, which means you design the auctions in a way to preserve monopolies, because people will pay more for monopolies than for competition. If instead you just had the restriction that the next wireless auction of 60 megahertz, neither Verizon nor AT&T were allowed to acquire it, and the auction would be among the rest, you could instantaneously have one or two more national wireless competitors. The spectrum auctions could have changed it. Yeah, the spectrum auctions could have changed it. And I think Fred's point is right, that the whole debate about network neutrality would be mitigated if there were 7 or 8 different national high-speed internet access companies available. I think that would completely vitiate that issue.
The Uber regulator, Chris Yu, is going to have my butt if I don't end this session now. I'd like to thank our panelists and our audience.